You may have heard the term Iolta account, I-O-L-T-A. What is that? The exact meaning is it is interest on lawyer trust fund accounts. I have selected several videos to help explain the integration between Clio, QuickBooks, and LawPay, and how that can help attorneys avoid legal problems and run their offices more efficiently.
Hi, I'm David Holterman. I'm the General Counsel of the Lawyers Trust Fund of Illinois. I want to talk for a few minutes about an important aspect of your practice, which is holding client funds in trust through an Iolta account. Iolta stands for Interest on Lawyers Trust Account, and it simply describes a type of client trust account designed to hold client funds in trust. Holding client funds in trust is a requirement of the Rules of Professional Conduct, specifically Rule of Professional Conduct 1.15, which provides that lawyers must hold client funds in one of two types of client trust accounts. The first is an Iolta account, and the second is a separate non-Iolta client trust account established for the benefit of an individual client. In both cases, the client trust account must be an interest-bearing account. However, in neither case may a lawyer collect interest that is earned on that account. When should you use an Iolta account? According to paragraph F of the rule, an Iolta account is to be used for the deposit of client funds that are nominal in amount or to be held for a short period of time. In many cases, this describes funds such as security retainer payments or settlement amounts that will soon be distributed among several parties, including the client, the lawyer as a fee, and then any lien holders such as medical providers or expert witnesses. Interest that is earned on Iolta accounts is directed to the Lawyers Trust Fund, which, under the instruction of the Illinois Supreme Court, uses those funds to support legal aid programs throughout the state of Illinois. Before Iolta was started in 1983, these funds were held in non-interest-bearing accounts. Participating in Iolta is a simple matter. There are nearly 400 financial institutions in Illinois that are eligible to hold Iolta accounts. You can find the list of eligible financial institutions, instructions, and the enrollment forms on our website at www.ltf.org. You can also contact us for information and assistance in establishing your Iolta account. Safeguarding client funds is an important part of your professional responsibilities as a lawyer. I cannot overstate the importance of understanding the requirements of the rule by reading the rule and also looking for background information in the ARDC's Client Trust Account Handbook. You can also contact us at the Lawyers Trust Fund for questions both about trust accounting and about the Interest on Lawyers Trust Account program.
So this week I want to talk about the importance of handling client funds. Lawyers getting in trouble because of mismanagement of the Iolta account happens a lot. I can tell you that in Illinois, I can't speak for other jurisdictions, but in Illinois, if the Iolta account drops down, insufficient funds when a check is presented, they have to report it to the disciplinary agency. And so the ARDC gets quite a number of reports from the bank because your account has insufficient funds in it. And of course, this makes a lot of lawyers uncomfortable and worried. But here's the thing. How many of you are managing your Iolta accounts? I mean, intentionally managing them. Not just putting money in them and forgetting about it, but actually keeping ledgers. You really need to be able to be, have the accounting ability to segregate the funds so that you know that these are funds for this particular client, these funds go to another client, and so forth and so on. You can get QuickBooks, you can get a couple other software programs to do that, but the most important thing is you have to do it. I've actually seen cases where lawyers were solo or small firm practices for decades, and they never paid attention to the rules. So at least for Illinois, you can go to the ARDC website and there's a really great primer on there about how to handle client funds. And of course, the main most important thing is you don't put your client funds with your personal funds. You keep everything separate and segregated. And really think about it. How else can you tell how you're doing? How else can you gauge how much money you're making from year to year if you don't have any accounting in place? And I know I've talked to a lot of lawyers and they say, oh, but the Iolta rules are so difficult. You're expected to understand them. And if you don't understand them, then get an accountant who can help you understand them and then keep track of it. I tell a lot of my clients, make a date with your money. Make sure you're looking at your accounts receivable. Make sure you're looking at who owes you money, who doesn't owe you money, who's paid. These things have to happen. And for a lot of small firms, they're not doing this. So you don't want your wake-up call to be a report from the bank to the disciplinary agency. I hope that you'll listen to this video and you'll really think about honestly whether you're handling your money in the best way that you can. So anyway, money is important. If you make a date with it, show it you love it, there's a very good chance more of it will come to you. So have a great weekend. I'll talk to you next time. Bye.
Hello and welcome to Clio. My name is Colin and I'm a training specialist here at Clio. Today we are taking a look at the QuickBooks Online integration. We offer an integration between Clio and QuickBooks Online to ensure we can bring your invoices from Clio to your firm's accounting tool. With the current integration, you can sync contacts and bills between the programs. Any payments or credit notes on those bills will also be brought over. First, we have some recommended settings in the QuickBooks Online account to ensure a smooth sync between the programs. Inside of QuickBooks, open your company settings, select the Sales tab, and click the pencil icon to edit sales form content. Ensure the box beside Custom Transaction Numbers is checked, and then click Save. From here, proceed to the Advanced tab, and under Other Preferences, click on the pencil icon again, and ensure Warn if duplicate bill number is used is turned on. Then click Save. Now let's return to Clio. In Clio, first go to your settings, then select Bill Syncing under System on the left, and from here select QuickBooks Online. You're able to select to connect to your accounts. Select Authorize. Once you have selected to connect your accounts, check off the box that says Export Bills from Clio to QuickBooks Online. Match each item to the code you want from your QuickBooks Online chart of accounts. Once everything is set up the way you'd like to see it, click Update Sync Settings. Now you'll see your information start to sync over. When you return to QuickBooks Online, all of your approved bills in Clio will show on the Transactions page in the Sales area. This is also where you can find payments and credit notes that were applied to those bills in Clio. Editing of invoices or payments must be done in Clio for the changes to carry over to QuickBooks Online. Now let's go back to Clio and navigate to our support site, which can be found by clicking on the question mark at the upper right, and from the drop-down selecting Clio Support. This was a brief introduction to the QuickBooks Online integration in Clio, and for additional details from our support page, go ahead and type in your search term and review the articles that come up from it. Thank you for watching the overview of our QuickBooks Online tool, and I hope you have a great day.
Hi, I'm Claude Decloux, the Director of Education and Ethics here at LawPay. Today we're going to briefly discuss how LawPay helps ensure trust accounting compliance. LawPay was specifically developed with the legal professional in mind. We've taken great care to ensure that your firm can accept credit cards in compliance with both the ABA and most state bar guidelines. So with LawPay, client funds are properly separated into your trust account and operating account to avoid commingling. All Unearned fees are deposited into your trust account, while earned fees and invoice payments are deposited into your operating account. Processing fees for either type of transaction are deducted at the end of the month only from your operating account. That means if a client makes a $1,000 payment into your trust, that full amount goes into your trust account and it stays there until you move it so you stay compliant. Additionally, debiting from your Iolta account is never allowed by a third party or anyone. At LawPay, we understand the seriousness of a trust account violation, and we've built our system to keep you compliant.
Today we're going to be talking about a special kind of attorney, and what we're used to seeing are really well-respected attorneys like Dan and I, and attorneys are well known for their sterling reputations amongst the community, but sometimes you have an attorney that winds up as a defendant, and I think that's what happened in this case.
That is indeed what happened here. Usually there are attorneys in almost every chair in the courtroom. Unfortunately for this gentleman, he was in the defendant's chair. This guy's name is Cliff Branham. He's 36 years of age, and this case involves the actions he took in spending the escrow money that was sent to him by other companies. Basically, he had a real estate company, a place called Cornerstone Title, and his responsibility was to take money in escrow for real estate transactions. And several of these transactions didn't work, and the victims complained to Lexington Police Department, and Sergeant Jody Stowers did an investigation, and he found out that there were 3 victims initially, and then a 4th one came forward, and they relayed to Sergeant Stowers that they had given Cornerstone Title, and specifically Mr. Branham, amounts of money between $27,000 and about $95,000 for a variety of real estate transactions.
So how much did he get away with total? Any idea?
When all was said and done, it was just about $240,000.
And that's the #1 rule of lawyering: don't take your client's money.
I remember that from new lawyers training when I passed the bar exam in 19, and we had to sit through training, and they said, do not spend your client's money. It's a very basic and fundamental rule. And what this guy did is he took the money, put it in his escrow account, and then he told the investigators and eventually the court that he used it to pay corporate expenses. We can't prove any differently. We didn't find any records that showed gambling debts or drug usage or anything of that nature. Mr. Branham is a graduate of the same law school I was, and of most of the people that work here, and several of the people that I know him personally. So he lives here in Lexington. He has a very nice and large house that is going through foreclosure. So when it was all said and done, he was charged with theft by failure to make required disposition, 4 different counts for spending the escrow money for these clients. He eventually pled guilty. He was sentenced to serve 8 years in the penitentiary. He is now at the Rotorua Corrections Center, which is where people report to before they get shipped out to wherever corrections is going to send him. I will be shocked if the judge doesn't shock probate him, so to speak, because he's been telling people since 2010 that he was going to pay them. He has yet to pay a dime of this money that he took, but I expect that he will be released from prison soon, and he will make some form of restitution to these victims.
Well, great. So he's in there with, well, I guess not his former clients, but possibly former clients.
One hopes not, but he is in custody, and in my humble opinion, deserves every day of it for the way he treated these innocent victims.
Yeah, that's a lot of money to take.
That
Well,
is.
thanks, Dan.
Hello and welcome to Jack's Law Office. I'm Jack Carney DeBoard, attorney at law. Today's video tip is about the question that was recently raised to me, and that is this. Client paid an attorney sum of money, $2,000, for a retainer for a certain kind of domestic case. The next day, the problem resolved. No work had to be done. He called the attorney. What should he be entitled to, and how should he be given his money back, or should any money be given back at all? And the answer is this. Monies put in a trust account are the monies of the client, not of the attorney. They are not the money of the attorney until they are earned by the attorney. So, theoretically and logically, if you gave an attorney a sum of money for a case today, no work was done, the next day you walk in the attorney's office right away and say, you know, hey, I really appreciated everything you did and your advice and whatnot, but things worked out. We're back together. We don't need you. You should get almost all, if not all, of your money back. Now, you may have in your contract that appointment you had yesterday, maybe that hour or two or whatever amount of time should come out of that trust account. That should have been explained up front. But just remember, you should be able to get some or all of your money back as it relates to that trust retainer, as long as no work was done. Okay? So there you have it, today's video tip answering the question of, I have given an attorney trust monies, I've worked out my case, it was the next day, should I get any money back? I'm Jack Kearney DeBoard.
And I am Lynn Chase, and I hope that these videos have given you a better understanding of the significance of proper trust fund accounting and how to protect your lawyer from being suspended or losing their practice. Thank you.